This is a slideshow basically on the sufficiency of complaints, whether the trustee brings a preference case or a fraudulent conveyance case, whether there's enough information in the complaint provided in relation to the allegations that are being made. This is a 2009 North Carolina bankruptcy court level case. And fact pattern is a little bit complicated. The trustee brought preference actions against a number of defendants, and the trustee was alleging that the debtor, Care America, was using another company, BER Care, as a conduit. So in other words, the debtor was transferring money to BER Care because the debtor was concerned it wouldn't have access to the money, that it was being that there were collection actions against the debtor, and so wanted to make sure vendors were paid allegedly, so transferred money to BER Care, and BER Care acted as a conduit, according to the plaintiff, to transfer money to other defendants. So the trustee then sued those defendants. So the question is, was the trustee's complaint adequate in alleging enough facts to survive a motion to dismiss? The applicable rule is 8A2. Pleading that states a claim for relief must contain a short and plain statement of the claim showing that the pleader is entitled to relief. So what does that mean? It's Federal Rule of Civil Procedure as applied, as referenced and applied in full by the bankruptcy rules. Same with 12B, applied by FRBP. Excuse me, 7012. 12B6. Well, I already described what the trustee was alleging, so I'm not going to repeat that. The defendant argued that, hey, it's not enough facts. You didn't allege with enough specificity how BER was a conduit, when it was a conduit, is this property of the estate or is it property of BER? Not enough information for the ultimate defendants to draft answers. That's the allegation. Not a lot of facts there. Bank accounts of BER Care were used by the debtors as a conduit to transfer funds. Also, there's a bare bones assertion of insolvency. I'm going to back, yeah. So this is a sort of a grid we made. The U.S. Supreme Court ruled and applied higher standards for pleadings, which the bankruptcy courts have applied in bankruptcy cases. And the new standard is a complaint has facial plausibility only when a plaintiff pleads sufficient factual content to enable a court to draw a reasonable inference that a defendant is liable for the alleged misconduct. So there's a new standard. It's a plausibility standard. Is this complaint plausible to support the allegations? Is it stating enough facts to pass the plausibility standard that the defendant is plausibly liable on these claims? So the court is applying this new case law and determined that one of the things that the complaint did not specify was the nature of the antecedent debt. Didn't give any facts, just said there is an antecedent debt, sort of mimicking the requirements of 547 of the Bankruptcy Code, but not explaining why there was an antecedent debt exactly. And in this situation where the transfer is from a third party that has an affiliate of the debtor, it's even more important that the facts are clear. Secondly, the court found insufficient facts to support the trustee's contention that the funds came from the debtor to BER to the defendants, which is the main allegation that's being made, not enough facts to meet the plausibility standard, not enough detail. Not enough facts to show insolvency. Can't just say it's insolvent anymore after these Supreme Court rulings. You have to give some kind of factual evidence of that. Also, the trustee was alleging insider status. There's got to be more facts showing that. And as far as the trustee's arguments, the trustee is saying, well, this is too much of a burden for a trustee. It's going to halt avoidance litigation or make it very difficult. And the reaction from the court is, that's first of all, that's the law that's being applied. And you have access to a lot of information, Mr. Trustee. The trustee has access to discovery powers under 2004. It has access to all the books of records. So the court is saying that's not an excuse. You just have to work a little bit harder, and your complaints have to contain more specificity. So the motion was granted. The dismissal motion was granted. Conclusion is that plaintiffs can't file bare-bone complaints. They have to develop the facts, especially in a situation like this, where there's an allegation of a conduit and more complexity. Also, what I took away, even in just a regular plain vanilla preference case, the plaintiff has got to allege some facts establishing that there's an antecedent debt. It's got to provide the names of the transferees, transferor, dates and amounts of the transfers, valuation, some kind of insolvency analysis, etc. The court also opined that we're not looking at a probability percentage here. We're just saying that there's more than a sheer possibility that the defendant acted unlawfully to establish and meet the plausibility standard, and here wasn't met. So 2010 Bankruptcy Court Florida case. Multiple debtors go bankrupt with affiliates, and the trustee sues the bank, one of the lenders, for a fraudulent conveyance. Bank moved to dismiss under 8A. Trustee did not break out exactly who paid the money to Key Bank, but alleged that by the time of the petition date, all these debtors had become jointly and severally liable and guaranteed loans, and so it wasn't necessary. Key Bank said it's not, complaint should specify exactly who paid us, where and how we received the funds to survive an 8A motion for this dismissal. 8A. The court agreed with the Care America court that we looked at and decided that the trustee just has to do a bit more work, and the trustee would have access to this information. And here, the complaint did not specify the total loans, why there were loans, which debtors were obligated on the loans, which entities were the source of the funds. There's way too much vagueness to support a clawback action based on the U.S. Supreme Court standards. This is a 2011 Delaware case, again involving complaint sufficiency. And in this case, there were a couple of issues with the complaint that the defendant raised in its 12b6 motion, which applied Rule 8A, a pleading that states a claim, Federal Rule of Civil Procedure 8A, pleading that states a claim for relief must contain a short and plain statement of the claim showing that the pleader is entitled to relief. That's a pretty vague statute, but it's been interpreted extensively by judges in case law. And there's 12B, 12B6. Okay, so the defendant argued that there was an Exhibit A listing, basically like a spreadsheet listing what was paid, and I'll show it to you in a second. But there wasn't any proof of transfers. There wasn't any invoices, bills, so there wasn't any evidence supplied. Trustee responded, "Nah, we don't need to supply evidence at this stage, and there's enough facts for you to know what's going on here." The problem with the complaint is that it had this in it. There were multiple debtors, and it didn't specify which debtor paid the defendant. Also, it stated that there was an antecedent debt, but it didn't show how. It didn't allege a debtor-creditor relationship or give facts that would support the existence of an antecedent debt. And an antecedent debt vis-a-vis which debtor? Who knows? That's the Exhibit A. The court found that Exhibit A was okay. That's enough. You don't need, the trustee doesn't need to supply actual copies of invoices and canceled checks. However, here the trustee's complaint was deficient because it's not saying who the debtor was that paid the defendant, and that's elementary. So so the complaint was deficient in that respect. Also, it didn't explain exactly why there was an antecedent debt or provide any details. You can't just say defendant was a creditor. You have to show why. Why was he a creditor? A little bit more of a showing is needed. So they granted the motion, but granted the trustee leave the complaint, amend the complaint. So he's going to go back and, excuse me, fill it in. And not sure this was, it's great for everybody else, but I'm not sure this was a profitable way to spend money on lawyers. So, there are multiple debtors. Obviously, what the takeaway is, there's got to be at least some level of a detail supporting who's paying us, who paid us, who paid the defendant in the preference period. You can't just say might be one or the other. Also, there is a ruling that a spreadsheet is sufficient that shows numbers, dates, and amounts. However, you do need to make a showing of why there's an antecedent debt. This is another case attacking the sufficiency of a trustee filed complaint, Bankruptcy, Florida, 2012. Well, all you need to know is that there was a trustee appointed, in this case a plan trustee, and a preference case filed, and the defendant brought a motion to dismiss. Rule 8A, whatever that means, a short and plain statement of the claim. Well, the defendant sort of made the same allegations as in the last case in his motion to dismiss. The trustee provided an exhibit which detailed information. The trustee specifically gave the name of the transferee, the check numbers, the date of the check, whether it's cleared, not cleared, the precise number of each transfer, and the invoice number associated with the transfer. The defendant argued that the complaint is insufficient to create a plausible inference of liability because there was no suggestion that the defendant was actually a creditor of the debtor. The nature and amount of the antecedent debt that was paid. There was an exhibit of payments, but apparently there wasn't an allegation that there was an antecedent debt or a fact background on that issue, and that the defendant would have received. There was no detailed showing of why the defendant would have received more in the preference period than it would have in a hypothetical Chapter 7 case. Well, this does not go so favorably for the movement. Here the court is basically saying it's a fact issue. You're saying that the invoice numbers don't relate to actual real invoices, that you need to see the invoices. And the court said, hey, this is a fact dispute. This is an issue for litigation. It's not an issue for insufficiency of complaint and a motion to dismiss. If you're disputing that these invoice numbers relate to actual invoices, then that's an issue for discovery or summary judgment during the case. Also, the court concluded that the issue of the 547b5 issue of whether the defendant received more in the preference period than it would have in a hypothetical Chapter 7 case is also a fact issue. It's a fact issue. You can raise that later in the case, but we're not going to dismiss the case. You can argue that later. The court also pointed out that the trustee incorporated by reference its disclosure statement. So here the court is saying that's sufficient. You're going to incorporate the disclosure statement as everything you could possibly need to know about this case as far as factual allegations are included in the disclosure statement. The exhibit certainly provided sufficient information for the transferee to admit or deny the allegations and assert any affirmative defenses. And this is that what was presented in this complaint is sufficient to create the plausibility that a claim, it's a plausible inference that a claim existed against the defendant for preference. So, motion to dismiss denied. Well, this bankruptcy court, I think the courts are in conflict here, but this particular bankruptcy court permits factual allegations to be incorporated by reference, in this case to a disclosure statement. And the fact that the creditor did not detail 547b5, the Chapter 7 hypothetical liquidation issue, is a factual question. In other words, the court is saying enough has been said here, and if you have an issue, you raise it as a fact issue or find out more about it in discovery. But it doesn't go to the plausibility it doesn't go to the plausibility issue that it's plausible, given the representations made in this complaint, that the defendant might have liability for in a preference case. This is another sufficiency of complaint case where a trustee is suing one of the top bankruptcy law firms in the country. So I wonder how this is going to turn out. Okay, so Chapter 7 trustee Phaedra Spradlin, I apologize, Phaedra, if I'm mispronouncing your name, trustee for U.S. Coal Corporation, decides to sue Prior Cashman for the avoidance of preference and fraudulent transfers. Prior Cashman files a motion to dismiss based on 12b-6, alleging that the allegations failed to state a claim upon relief can be granted as a matter of law because the claims do not reach the plausibility bar. They're not plausible enough. They're not pled with enough detail. Trustee filed an amended complaint and sought to continue with the lawsuit. Trustee alleged that the debtor had retained the defendant, Prior Cashman, as legal counsel in 2006 and paid with stock so that Prior would defer attorney's fees until the debtor obtained financing for its project. Just to finish the last slide, the trustee is basically saying that the debtor didn't get anything in return for its stock. That's why it's a fraudulent conveyance, and that the legal services were rendered to affiliates of the debtor, but not the debtor. This is 12b, 12b-6. Federal Rule of Civil Procedure 12B applied by the rules of federal bankruptcy procedure. Also, Civil Procedure Rule 8A, which is also applied by the bankruptcy rules. In other words, the bankruptcy rules apply the federal rules, incorporate the federal rules. Also, FRCP 9, in the situation where allegations of fraud are made, 9B applies. In alleging fraud or mistake, a party must state with particularity circumstances surrounding fraud or mistake. It's a higher level of requirement of detail and specificity for the complaint because fraud is alleged. I have to go into the facts a little bit because it's complicated, a little bit complicated. The trustee is basically saying this. The subsidiaries paid for these legal fees and they never got any legal services. So the trustee is also representing the subsidiaries is saying, well, I'm suing on behalf of the subsidiaries. And while, yes, the money came from the debtor, the debtor's money came from the subsidiaries, and the debtor is really just acting as a conduit. So the debtor's just the middleman. The subsidiaries are paying the debtor's paying prior, but really it's the subsidiaries paying prior, and the subsidiaries didn't get any services. So essentially, the subsidiaries are paid for nothing, and the debtor got the legal services, but didn't pay for them. So the trustee is suing on behalf of the subsidiaries to get the money back, because her argument is that it was just a conduit. It wasn't debtor's money, really. So the trustee also said there was a preference, in addition, made by the debtor. So based on this theory, the trustee wants all the money back, and as well as the alleged preferential payment back. Well, the court bought Pryor's argument, which was basically a sufficiency issue. Pryor argued, trustee's just saying, okay, the debtor got a bunch of money from subsidiaries, and that's it. Trustee's not specifying exactly what subsidiary paid what, the amount, the date. There's no fact basis, or not enough fact detail to justify defeating a motion to dismiss. Why? Because Pryor can't really address each separate transfer from a subsidiary to the debtor without knowing what they were, what transfers, how much, when. So the court found that these blanket allegations, given that this is a fraudulent conveyance case, is not adequate. Not that the complaint is not adequate. Not enough detail. This is a page out of the opinion. And basically, the defendant has the right to be able to know what transfers he's being sued for exactly. And here, it's not clear what the transfers are. It's a transfer from the debtor, but it's really a transfer from the subsidiaries. What transfers? So there's not enough clarity for Pryor to put in an adequate defense. Another problem with the trustee's lack of specificity is that it could result in arbitrary rulings. The court saying anybody that got paid from the debtor could now be subject to a fraudulent conveyance lawsuit, and the allegation is somehow they really got paid by a subsidiary. It could apply to anybody, any payment. There's got to be more specificity to show exactly why the debtor, or at least in more detail, to show in more detail why the debtor was a conduit and what payments exactly were transferred to the debtor by the subsidiary. And since these facts were not alleged in sufficient detail, either in the original complaint or the amended complaint, the case must be dismissed. As far as the trustee's allegations of actual intentional fraudulent conveyance, then specificity is even required at a higher standard. So the complaint has to be dismissed for that reason. There were no circumstances pled which implied a fraudulent intent on the part of the defendant. So, page from the opinion regarding the requirements of Rule 9b, the plaintiff must allege the following: date of the transfer, amount of the transfer, name of the transferor, name of the initial transferee, and the consideration paid. Here, the date and the amount are missing. However, the court held that the part of the complaint alleging preferential transfers was sufficiently pled and can continue. It's a lower standard of specificity that's required in a preference case, and the defendant can find out from discovery if it needs to unearth additional detail. And this is a page from the opinion, and not to beat a dead horse, but in this case, with regard to the preference transfers, the complaint alleged and identified the name of each debtor, transferor, the name of each defendant, transferee, the form of the transfers, in this case checks, total amount of the alleged preferential transfers made by a particular debtor, transferor, and this provides fair notice. This is a 2007 Ohio bankruptcy level case. Facts of this case: defendant was in the vehicle leasing business. State Bank brought an adversary proceeding against the Chapter 7 trustee to seek a determination that it had priority, its liens had priority over other creditors, and that certain leases were not property of the estate. Trustee filed an answer with counterclaims. The counterclaims were actions for fraudulent conveyance, recovery, and preference recovery. The bank sought dismissal of the counterclaims, saying the allegations were thin, did not meet the bar of 12b-6. Now that's the issue. This is the applicable law, Rule 8A, FRCP Rule 8A, also as applied in the bankruptcy rules. Rule 9. The trustee alleged a lot of different things. The receipt of voidable preferences, the receipt of fraudulent conveyances, breach of fiduciary duty, and made allegations that the debtor was involved in fraud and State Bank was involved as well. State Bank argued the fraudulent conveyance actions were not pled with particularity as required with a fraudulent conveyance case, especially actual fraudulent conveyance. And even the preference claims were not adequately pled. Well, the court agreed with State Bank, and the problem that the court found was that although the trustee did allege some facts that the debtor's sole shareholder was engaged in fraudulent schemes, and the alleged transfers to the bank was part of that fraudulent scheme, the trustee didn't break it down into any actual transfer. It was just a vague allegation. The trustee didn't identify any actual transfers or amounts or dates or anything like that. So while the trustee's actual fraudulent conveyance count failed for lack of particularity, also the preference count failed. And preferences are easier to plead. But here, the trustee didn't identify any of the particular preferences, any of the particular transfers, when, how much. And the court found, hey, the bank is not receiving enough notice because it can't formulate defenses if it doesn't know what transfers the trustee are alleging are preferential. And the court gave examples of affirmative defenses, just like contemporaneous exchange or ordinary course of business. If the trustee is not going to even identify what transfers are preferential, when they were made, how much, it's impossible for the bank to come up with affirmative defenses that it needs to plead in its answer. Well, the court granted the trustee leave to appeal. But the important thing here is that even in a preference case, it's pretty clear in an actual fraudulent conveyance case, there's a higher level of pleading, even in a constructive fraudulent conveyance case. There's a lower level of requirement in a preference case, but you can't just parrot the statute. You have to set out some facts, especially, what the transfers are. Which transfers? When were they made? How much? You have to identify that there were transfers made, and with some specificity so that a defendant can draft an answer, put in affirmative defenses. So it's rare to see a preference complaint dismissed because it's not that easy. It's not that hard a burden to meet, but sometimes they are dismissed, and even preference complaints have to have some basic information. This is a 2010 bankruptcy level Delaware court case, a fairly complicated case. It involves the redemption of notes from note holders and a trustee suing and claiming that these redemptions and related contracts and agreements constituted fraudulent conveyances. The court went into the facts in a lot of details, and basically the note holders sought to dismiss the case. They also sought sanctions under 9011, and they also asserted that these were protected payments under 546 as settlement payments. Rule 9 again. It's a constructive fraudulent conveyance case. The defendants asserted that Rule 9b applies. The defendants argued that sanctions are appropriate here since they requested that the trustee voluntarily dismiss the case after pointing out what they felt were deficiencies in the complaint, and the trustee refused. So that's the issue. Well, there were a couple of different arguments. That basically, the note holders were arguing that this is some kind of a disguised preference case, that there is an antecedent debt. It was payment of a note. Number one, and so the whole thing is completely wrong. And then number two, under 546E, they shouldn't be sued because of the settlement payment, so they're protected. And the complaint is insufficient on its face at any rate. Trustee argued that these are fraudulent conveyances. The debtor was insolvent, and he stuck to his guns. Not going to go into the complexities, but basically the court ruled that the trustee just parroted the law, fraudulent, especially state law, state fraudulent conveyance law, and wasn't sufficient, didn't say exactly how this law applied. Some of the counts weren't dismissed, though. The court, with respect to the 546 argument and the argument that these were antecedent debts, basically the court said, I'm required to accept the allegations as true in the complaint, and maybe the trustee can prove it, but the court noted that it believed it was remote, and that these defenses were inappropriately asserted in a motion to dismiss and can be asserted in summary judgment or a trial, but it's not a motion. It's not a sufficiency of the pleading issue. He's alleging that there was not an antecedent debt, and that's his allegation. It has to be dealt with. It's a fact issue. As far as sanctions, the court found, especially since the court didn't dismiss all accounts, didn't find that the trustee's claims were frivolous, legally unreasonable, without factual foundation. At least he didn't find it yet. One wonders if that finding is going to be made later in the case, but didn't find it at this stage, and refused to impose sanctions because such sanctions should only be imposed under very limited circumstances. Otherwise, you discourage people from using the court system. I happen to think maybe that's a good idea. And it spawns satellite litigation, counterproductive to efficient disposition of cases. It's very hard to sanction a trustee. Very hard. In fact, I've seldom, almost never have seen a trustee sanctioned. In fact, I don't think I ever have seen a trustee sanctioned. I'm sure they have been sanctioned in my lifetime for bringing preferences in fraudulent conveyance cases, but not in any of my cases. And I don't remember reading a situation where a trustee was sanctioned. This is a bankruptcy level case, 2011, from Iowa. So here the trustee represented a debtor that was the largest kosher meat packing plant in the nation. Anyway, the trustee filed a complaint against the defendant, alleging that he was an insider for fraudulent conveyances and preferential transfers. Defendant moved to dismiss. So, of course, the issue is there a higher standard of pleading required, and do the pleadings meet the standard, the new U.S. Supreme Court standards? Same rules. Well, the defendant argues that, first of all, the trustee lists some transfers and said, well, these are either allegedly fraudulent conveyance or preferential. So that's not good enough. According to the defendant, it needs more specificity. Not enough specificity since the trustee was alleging fraud, a fraudulent transfer. So he must adhere to a higher level of specificity pursuant to 9B, and he didn't do that, so must be dismissed. Trustee says, Well, it doesn't apply to constructive fraud. 9B doesn't apply. 9B only applies to actual fraud. Court agreed with the trustee uh, and held that the higher pleading standard of 9B does not apply to constructive fraudulent transfer claims, and the complaint should not be dismissed. Also, the trustee alleged at some point that he was not aware of equivalent value, and that's a sufficient factual allegation on the issue of lack of equivalent value. Additionally, the trustee alleged fraudulent conveyances and preferences and not required to distinguish between the two. This can be fleshed out in the discovery process, and it's sufficient notice to the defendant to put in an answer. So the takeaway is 9B does, at least according to this bankruptcy court, does not apply to constructive fraudulent transfer claims. And 548A1B, constructive fraudulent conveyance claims must satisfy only Rule 8A to survive a motion to dismiss. Okay, 2010 Bankruptcy Court, Delaware. This is the Pillow-Tex bankruptcy case, and the trustee sued one of the vendors alleging fraudulent conveyance transfers, actual and constructive. The defendant filed a motion to dismiss, and the grounds were there's not enough specificity. There's an actual fraudulent conveyance count here, and not enough specificity, not enough information to put in an answer. Applicable rule 12B 6. Also, of course, 9. Missing a slide on that. So, defendant is arguing, again, this, basically the same thing. You gotta give me more detail. The plaintiff is saying, hey, it's an alternative allegation and it should be left in there. Alternative to fraud, to constructive fraud. This was a pretty clear case a pretty clear win for the defendant. The court noted there's bare bone drafting, just basically copied and pasted that section of the bankruptcy code and didn't provide any detail. Not good enough. However, the court found that there was no bad faith involved, and so the plaintiff had the opportunity to amend the complaint and could refile it. Case out of Guam, 2016. So this is a divorce situation. Wife transfers property to the ex-husband or to the husband under threat by the husband, and allegedly for inadequate consideration paid by the husband. Bankruptcy, trustee appointed, trustee sues husband, get the property back. And the husband says, or the husband's lawyer says, the complaint is lacking specificity for a complaint under 548, actual fraudulent conveyance, 548A. Well, should it be dismissed under 9B or 12B or no? Well, the husband's lawyer argued that there's just not enough specificity here, and trustee contended that he met the requirements. Well, the court found that the husband was correct, and what's interesting here about this case is that the trustee, in opposition to the motion to dismiss, starts providing a lot more factual basis for the complaint. There was duress, there were threats, blah, 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 to buttress his argument. But the court is basically the court basically responds that should have been in the complaint, not in the opposition to the motion to dismiss. The end of the story is that the trustee gets a second bite at the apple and can amend the complaint. So, takeaway here is the the opposition to the motion to dismiss maybe could have been framed a little bit differently. But the real lesson is a lot of times these trustees just get another bite at the apple. So this many times this kind of litigation, sufficiency of complaint litigation, is a waste of time unless there's a possibility that the trustee cannot provide more specificity, which does happen. So it's a case by case analysis. 2008 Maryland case. So the debtor was Air Cargo in the business of providing services to airlines to move cargo. The defendant was a tech company. Debtor filed for bankruptcy, and the trustee sued the defendant vendor under constructive fraudulent conveyance, 548B, not A, not actual. Defendants moved to dismiss. So the defendants moved to dismiss based on a 9B claim that's alleging some kind of fraud. The complaint should meet a higher standard. Trustee argued that the complaint was sufficient. There were allegations of misrepresentation and fraud, and sufficient detail. And the defendants argued, no, there wasn't, not enough specificity. Failed to establish the absence of fair consideration, and failed to allege a fraudulent conveyance that met the 9B pleading standards. Well, the court found that the plaintiff is alleging constructive fraudulent conveyance, not actual fraudulent conveyance. 9B does not apply. 9B does not apply. So the motion to dismiss was denied based on that. Here, the judge noted actually the trustee alleged more than he had to. The only thing the trustee has to allege is lack of fair consideration. And here, he's implying lack of fair consideration by saying there was misrepresentation and fraud, and it's sufficient. In fact, the court says the trustee hit the bull out of the park, and even if it had been an actual fraudulent conveyance complaint, the complaint would have been sufficient. So, motion to dismiss denied. So the takeaway here is, again, same takeaway. If constructive fraud is involved, the 9B standard is not brought into play. It doesn't hurt to be as particular as you can be. One of the issues that I've seen raised a number of times is, even in constructive fraudulent conveyance, whether the claim of inadequate consideration has been set out with enough particularity. So it certainly doesn't hurt to set out the basis for that. Also, one last thing is that insolvency must also be, the opinion didn't deal with that, but just to be clear, in a constructive fraudulent conveyance, lack of fair consideration, and that the debtor was insolvent at the time of the transfers. You have to show both. So bankruptcy court level 2013 case. So this involved a failed Ponzi scheme that ended up in bankruptcy. Trustee was appointed, and trustee sues the bank where the funds were deposited and alleges all kinds of things. The bank knew this, the bank knew that, it was involved in the Ponzi scheme, etc., etc. And so it sues the bank the trustee sues the bank for fraudulent, actual and constructive fraudulent conveyance. The bank moves to dismiss. Surprise, surprise, 12B6 and 9B. The court granted the defendant's first motion to dismiss and then allowed the trustee to amend and file again. Trustee filed again, and the defendant filed another motion to dismiss. Defendant says, not good enough. So that's the issue, whether defendant's motion should be granted and whether the trustee's complaint still fails to meet the pleading requirements of 8A and 9B. 12B, 9B. Another reason the defendant another ground the defendant gave for dismissal was that it's a mere conduit. We're a mere conduit. We're just a bank. That's an affirmative defense. The court issued a very detailed and long opinion. So this is the court's ruling on the initial complaint. The trustee found that this was a textbook example of a so-called shotgun pleading. So a shotgun pleading is when there's a huge fact allegation section, and then this entire section is just referenced for each and every claim. So that when you read the claim, you have to go back and figure out, okay, where in this tremendous fact section is the allegation related to this particular claim. And the court ruled it's no good. You can't do that, and it doesn't meet 8A's requirement. And so the court, like I said before, granted leave to amend. So the defendant again argued that it's still a shotgun pleading. That argument worked the last time. Why not try it again? The court held, well, not really. The trustee this time made changes, made it shorter, and also had specific factual allegations relating to each complaint. So the court found that not every single claim was simply repeating the initial fact recitation by reference, and the complaint is no longer constituted shotgun pleading. The court also found that in a motion to dismiss, the conduit defense is not appropriate. That's an affirmative defense that could be set out in the answer, and it's a fact issue. So it's not going to help a motion to dismiss, which has to do with sufficiency of the complaint. Additionally, the court found the trustee failed to allege sufficient facts to support the aiding and abetting fraud claim. Also, the trustee failed to allege that with respect to the fraudulent inducement, fraudulent misrepresentation claims that the trustee made, the trustee failed to allege the precise statements or misrepresentations made, the time and place, people that made the statements, to whom the statements were made, etc. Not enough facts, essentially. Who, what, where was all missing here. And it didn't meet the higher standard of 9B. Court denied the motion to dismiss to the extent that it sought a dismissal of all claims, but it did grant the defendant's motion to dismiss with respect to some of the claims that were not adequately pleaded, as we saw in the last slide. Well, the takeaway is shotgun pleadings are frowned upon. They don't meet the Rule 8A requirement, and certainly without specificity are not going to meet the 9B requirement. So that's how to deal with a shotgun pleading.